Hey everybody, welcome back. My name is Elise, and this is 10 to Life, and we are talking all things true crime. If you remember, back in April, I brought you the story of Lily Peters, the 10-year-old girl from Chippewa Falls, Wisconsin, who was brutally murdered by her 14-year-old cousin, Carson Peter Burgers, and she was murdered by him on her way home from his house on a bike ride. Now, I don't know about you, but kids killing kids just hits a little different. It is one of the most mind-blowing crimes I can imagine. And for me, it's a little too close to home as a mother. But also, this wasn't just kids killing kids. This was a kid killing another kid who was a family member. And not only did he kill her, but he SA'd her body after the fact. And he admitted to police that he had actually planned all of it from the time they left his home together that evening on the bike ride. Think about that. He consciously decided that he was going to kill and SA his 10-year-old younger cousin at just 14 years old. At just 14 years old, he made a plan to do something so unspeakably horrific. Now, if you haven't watched those videos, go and take a look at that playlist because I break it all down for you, all of the yucky, gross, horrific, gruesome details, and it really will get you caught up with today's updates. And today's updates are about his court appearance this morning, his attorney's crazy argument to the judge, and what Carson's grandmother is saying in defense of him. So guys, let's get into it.
10 to Life with Elise starts right now.
If you remember in my last video, you might remember that the apple didn't seem to fall far from the tree. Carson's father, Adam Burger, is a convicted pedo who was incarcerated for 3 years for being in possession of inappropriate material involving young girls. It's not a stretch of the imagination to think that Carson may have been exposed to similar content from his father sometime during the 11 years before his conviction. And to be honest, the rest of his family mirrors similarly abusive and bizarre behavior. Because of the severity of his charges, which include homicide, SA, and SA of a child, he is automatically set to be tried in adult court. Carson's grandmother sent a letter to Judge Ben Lane pleading with him to send Carson to juvenile court. In her letter, she said that Carson is and always has been a kind, caring, giving, and loving person. Also saying, I don't have the words to explain the pain that our family is going through. And I'm sure that's true, considering all of the different facets of this family that have been accumulating through generations to create this horrible murder. And I can only guess that this grandmother is also the grandmother of Lily Peters, because her saying that her family has already lost too much and went through so much pain leads me to speculate as much, which would make her the mother of Carson's mother and Lily's father. She goes on to write about Carson's accomplishments in school, that his peers view him as a great role model and how he has never been in trouble, as if that somehow lessens the things that he's done, and the fact that he took the life of his 10-year-old cousin and brutally SA'd her after she was dead. Saying things like he has excellent character and positive behavior seems in very poor taste and almost like enabling behavior, to me at least. Going on to excuse his behavior as just a young boy who got mixed up and lost control just seems like a poor excuse for the actions that he committed, especially premeditated actions that he himself admitted to police that he had planned from the get-go, his exact quote. I can't imagine trying to justify this kind of behavior from my child or my future grandchildren or anybody, especially considering that they had just stolen the life of my other grandchild. How do you justify this?
In documents now made available to the public, CPB's grandmother pleads that the case be sent to juvenile court so he can get the professional mental health care he needs. In her letter, she describes CPB as a kind, caring, giving, and loving person. She noted that he was chosen as Student of the Month this past February by his 8th grade classmates. And she says her grandson is just a young boy who got mixed up and lost control.
The highlighting of his goodness ironically reminds me of pieces of the letter that his father had penned to his own judge for his case, in which he had said that Carson was the best of me. She underwhelmingly acknowledged that he does need to be punished, but doesn't think that prison is a suitable punishment. She begged the judge to send him to juvenile court to, quote unquote, get the help he needs, even mentioning that this is the opportunity to help a young boy figure out what happened and why, as though he is the victim here and needs help. No, 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 no. Her plea to the judge is clearly out of love and pain. I get that, because I can't imagine all of the pain that their entire family must be feeling. She was even mentioning a threat to her daughter's life and that of her family in this letter too. So I get it. They're stressed and they're heartbroken. And Lily's mother also condemned these online trolls for harassing her family. So it's hard to understand all of these inner workings within a family, let alone one with so much trauma that has happened generation over generation, because we have no idea what truly did happen to these kids, Carson included, behind closed doors, or what continues to happen behind them. But this letter just brushed me all sorts of wrong. The attorney for Carson also submitted a letter to the judge to ask that law enforcement and the DA be barred from making comments about the case to news outlets as it proceeds, saying that this case should be tried in the courtroom and not in the media. Judge Lane has yet to respond to those letters, and it remains to be seen if he actually will respond. But Carson appeared back in court today, and I have to say, I was a little surprised at the direction it took. Carson appeared by video with his attorney Michael Cohen for a brief hearing during which Carson's attorney, the DA, and the judge discussed what arrangements might need to be made for witnesses that are testifying at the preliminary hearing on September 1st. See, in Wisconsin, anyone charged with a felony has the right to a preliminary hearing, at which a judge must decide if there is probable cause to believe a felony has been committed by the defendant. Carson's lawyer also brought up concerns about a video that was posted to YouTube. Not this video, not any on this channel, but probably will after this. And the video airs what sounds like audio from a police officer, something that had apparently not yet been made public. So Carson's lawyer told the judge that the video includes information that he believes also is false. And he said it also includes information that he has not seen himself and is concerned that the video could create inappropriate bias or taint a jury pool. And he gets pretty heated as he delivers this argument and information to the judge. Take a listen.
Attorney Cohen, were there any other items that you wanted to address today? As discussed, we did receive some additional correspondence from you.
Your Honor, there's one issue. As the court knows, I wrote a correspondence and I did discuss the idea of some type of, certainly within the court's authority, some type of what I would call colloquially a gag order to try to limit certain pieces of information being disseminated to the public. Since the time that I wrote that correspondence, Your Honor, I have been made aware, as from what I can tell, at least 1 million people have been made aware that someone somehow provided information about this case in terms of specific pieces of evidence, video footage, phone calls, 911 calls, documents, and other things somehow have been leaked to someone who has now put a 30-minute video on YouTube where they have made my client into a cartoon figure. They have provided false information, or at least from what I can tell, false information. They have referenced information that, from what I know, I don't have, and from what I know from Mr. Newell's office, apparently they say they don't have. I have contacted YouTube. I have, on behalf of my client, attempted to begin a privacy confidential strike against that to have it removed. I have not heard back from YouTube Corporation yet on this. But from what I can tell, at least as of 3 days ago now, this video has been observed just by the time that it was released on June 3rd by over 800,000 to 1 million people. And frankly, Judge, it's still available. I will send the court and Mr. Newell a link if they want to see it. It's still available. But this is the type of concern that I have about this case. The amount of information that is direct law enforcement information tells me that somehow information has been leaked out that is of a significant evidentiary nature And I don't have it. But now almost 1 million people have seen it. And it has made my client into a cartoon figure, and it says things that are completely inappropriate. So to the extent that I now have evidence that something has occurred, I'm asking the court to, within its authorities, instruct anyone that it can, and I understand your limitations, that there will be significant consequences for leaking of evidence about this case to the general public in such a fashion that appears to me for the purpose of doing everything possible to potentially taint a potential jury pool or cause some type of inappropriate bias towards my client. I'm not going to put up with it, Judge.
All right. Attorney Newell, is that accurate that the state has no notice or information as far as where this information is coming from?
Until he mentioned it right now, I had no idea. And I guess I would ask for that link so that the state can review that to determine if it is in fact law enforcement video or some other video or what it is. I can't comment upon it now because I have no idea what is in that YouTube video. Obviously, the leaking of confidential information is already prohibited, so I don't know that the court has to take any additional action now. If the court wants to make a statement that sort of information that's troubling, if any sort of confidential information is leaked, I don't have a problem with that. And I talked to Attorney Cohen a little bit about this a while back when he filed the letter, but because there's no notice to anyone but the parties, I think the court could only put a gag order on the parties that are part of this action. I don't think there's no law enforcement has notice of any hearing today regarding what they're allowed to say or not say about that. Obviously, as an individual, I have certain constitutional rights as well under the First Amendment. I think I've done fine in not disclosing anything that is factually involved in this case other than is a public record and out to the public as of now. I don't have a problem with there being a gag order in this matter to not talk about the facts of the case at all while the matter is pending either by the defense or the state for that matter. I mean, as the court knows, we've also received favorable correspondence to the defendant, which is now part of the media having that, which is the letter that was provided to the court. I've seen in the media as well. So if it is in fact unfavorable video for the defendant, there is also favorable information that is being provided and made available to the media as well. I don't know how we stop people from filing things, and I don't know that there's a mechanism by which to seal it as it comes in necessarily, because as the court knows, the rules from the Wisconsin Supreme Court err on the side of transparency, that everything that is filed is seen by the general public, that it's open and available. Obviously, we don't control the media. Neither of the parties control the media in that regard. I, like Attorney Cohen, want the defendant's rights to be protected. The job of the district attorney is not just to convict people, it's to make sure justice is done in the matter, and I want the defendant's rights to be protected as well. I don't know exactly what the defense is asking for. It's just that the parties not talk about the case factually. I don't have a problem with that.
Attorney Cohen, are you aware of whether the posting party on this link is an entity that put this together, or is this an individual posting party? Do you have any information about that?
A few things. Judge, first, from what we can tell, it was put out by a man. It's called the Law and Crime Network. I will forward to your assistant, Your Honor, as well as to Mr. Newell, a copy of the link so that it can be viewed. I do not, and the next point, Judge, is that I agree with Mr. Newell. anything that is filed in this case with the court is a public record that can be disseminated. I understand that. The concern that I have, Judge, is that when you see this video, you will realize relatively instantaneously that the information contained in it, almost all of it, has not been disseminated to the public. It is not a public record. It is not in the court file. It is not something that's been filed for your review to determine whether it will be filed under seal or not. It is information that is drone coverage, drone video footage, 911 calls, police communication phone calls between law enforcement officers. It is documents. It is photographs. It is a 30-minute video, this montage with this gentleman making all sorts of completely inappropriate commentary. Who the person is, I don't know. My concern is not that, and I'm not asking that publicly, appropriately filed documents somehow be shut down. That's not what we're talking about. What I'm talking about is my concern that somehow, somewhere, somebody gave out someplace significant information about this case, actual evidence which would potentially be introduced at a jury trial that is not public. And that is my concern.
All right, I need to review this video because if that is the case, there are some concerns. I took an oath to uphold all the rights for our Constitution for the public and the First Amendment rights of our media and the public in general for information in this case, the defendant's rights and all the rights associated with him, the victim's rights that are in place for our Wisconsin Constitution and statute. So I need to make sure that everyone's rights are being met and upheld as part of this matter. And so I am concerned. I don't know if this is legitimate, as Attorney Cohen discussed. A cartoon image is made of the defendant, and so I'm not sure if any of this may be audio generated or illegitimate or not. It's hard to tell sometimes with digital production, but I need to make sure that all rights are being upheld in this matter. Attorney Cohen, I, as far as an order on other participants in this case, including public officials, the court does have some authority to address these issues and to restrict release of certain information by certain individuals. The court does note, though, that when there is a public official or an elected official involved with release of information or records, that under Chapter 19 of our statutes, that a separate civil action may be required to restrain that individual from releasing certain records. And if that is the case, this court may be limited in jurisdiction while acting in the criminal jurisdiction to issue an order against something that would be required in a civil jurisdiction matter. And so if that is the case, that would prohibit me from making any orders, but under other considerations, I may be able to do that. Do you understand?
Judge, and you've already read my mind, and maybe by your questions you had done that earlier. We are attempting, through an appropriate investigation that we can, to try to figure out how this information was released. I am fully aware of Chapter 19 and the FOIA and the mechanisms that certain persons have to perhaps get some information. However, as you know, Judge, the information that can be released pursuant to a Chapter 19 release or a Federal Freedom of Information Act is limited and strictly protected, especially in pending investigations or ongoing criminal cases. And so if, for example, something was released, I'll just say it perhaps mistakenly by what somebody would have thought would be an otherwise proper request, that does not mean that there are not actions or sanctions or remedies still nonetheless available. So we're investigating that, Judge. I don't have the answers for that today, but I was making the comments about the video because I became aware of that this week. And I didn't have a chance to get any additional information to the court prior to this hearing, but I had raised the issue tangentially, at least in my correspondence of a couple of weeks ago. The purpose of bringing the video to the court's attention today was to say, I wrote to you, now I have documented evidence that there's a potential issue. We're working to gather more information, and to the extent that you can, at least today, order some type of restrictions or perhaps admonish all those that would otherwise be listening to this about making sure that they follow the law moving forward. That may be all you can do today. I recognize that. But it is a serious situation, and I have to protect my client's rights to the best of my abilities.
Well, I think it's fair that I direct not only the state, but the defense, law enforcement, and any other parties who may have obtained information regarding this matter that remains confidential, that has not been released as a public record as part of this matter, or by any other public official according to Chapter 19, that it should not be released to anyone because it affects the rights and due process rights of the defendant. It affects the ability of the state to prosecute its case. There are a variety of issues that have consequences by releasing information that is still confidential in this matter. And so I would direct anyone who does have any of that information to not release it. And it goes for both sides. It's not just for the state and police, it also goes for the defense. So that is something that I will enter here today. And again, I expect that that goes along with the officials and the authority that has the custodial rights to those records. But also that means the individuals that are under their control. And everyone who is under the control of those individuals should maintain that confidentiality as well.
Now look, I am all about a fair trial and not doing anything to jeopardize this murderer facing the consequences for what he did to Lily. However, I don't believe this video alone, I've seen it, or the police audio alone, I've heard it, is enough to taint the jury pool. It's my opinion that the jury will need no convincing, given the evidence that we already know. I think that this is just a strategic and baseless argument by Carson's attorney as to hope for a mistrial or something in that direction down the line. Even if the police audio wasn't obtained lawfully, it doesn't necessarily pose any direct conflict to Carson himself. However, the judge said that he was concerned about the video as a whole, and he is going to review it. And the DA, Wade Newell, also expressed concern and said he will review it to see if it includes any legitimate law enforcement video. The complaint filed against Carson lists those three charges: first-degree intentional homicide, first-degree SA, and first-degree SA of a child. And if this case remains in adult court, where it is now, this guy, if he's convicted, he could spend decades in prison. So the next court appearance is scheduled for September 1st. And I'm following this one so closely because I just can't wrap my mind around the brutality of it all. To not only be 14 years old and concoct this plan, and he's made threats to her before in the past too, but to concoct this master plan of you're going to walk your 10-year-old cousin home or ride your bikes home, but you're going to veer her off into the woods onto a trail and lure her there, and then you're going to kill her by hitting her with the stick. You're going to strangle her. Then you're going to SA her once she's already dead, leaving bite marks on her body. And then you're going to flee the scene. And I believe he even I have to look in my older video, but I believe that he even told his younger sister what he had done to scare her when he got home. And then he went back to the place to move the body when he realized people were looking for Lily. I mean, there's just so much brutality in this and heartlessness that, first of all, that's why I can't even imagine why this grandmother is pleading for him to not go to adult prison and saying he needs to, this is an opportunity to save him, to help him. I'm sorry. My opinion, you can't save a monster like this. No, 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 no. And you're putting so many other people at risk. But also, I'm following it because I just want to know what's going on in the inner workings of his mind to make somebody do this. Again, kids killing kids is a whole different ballgame, and especially when it is family. It is just sick. Sick, 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 no matter how you slice it. So the next hearing is set for September 1st, and I will update you if we hear any more information between now and then as far as if anything does get issued from the judge regarding videos on YouTube or anything like that. I pray it doesn't, I really don't think it will. But we'll see if there's any other new information that surfaces between now and then. In the meantime, check out that playlist if you haven't done so already, or if you just need a brush up in this case and all of those details, and I will link it here. All right, guys, thanks for tuning in with me today. We are one step closer to justice for Lily, and I really, really hope we get it. This little 14-year-old gnat, I don't even know what else to call it, just like an evil little gnat, needs to literally pay for what he has done. It is disgusting. All right, guys, until the next case, stay safe. Bye.